Floro Cement Corporation v. Goresby. Facts: the municipality of Lugait filed with the SC a verified complaint for collection of taxes against the defendant Floro Cement Corporation. The taxes sought to be collected by the plaintiff refers to manufacturers and exporters' taxes for the period from January 1, 1974 to September 30, 1975, inclusive, in the total amount of P161,875. 00 plus 25% thereof as surcharge. Plaintiff alleged that the imposition and collection of these taxes is based on its Municipal Ordinance No. 5, otherwise known as the Municipal Revenue Code of 1974, which was passed pursuant to PD 231 and also Municipal Ordinance No. 10 passed pursuant PD 426 amending PD 231. Petitioner set up the defense that it is not liable to pay manufacturers and exporters taxes, alleging among others that the plaintiff's power to levy and collect taxes, fees, rentals, royalties or charges of any kind whatsoever on defendant has been limited or withdrawn by Section 52 of PD 463. It also contended that the defendant was granted by the Secretary of Agriculture and Natural Resources a certificate of qualification for tax exemption, entitling defendant to exemption for a period of 5 years from April 30, 1969 to April 29, 1974 from payment of all taxes, except income tax, and which certificate was amended on November 5, 1974 CQTEPD 463-22, entitling defendant to exemption from all taxes, duties, and fees except income tax, for 5 years from the first date of actual commercial production of saleable mineral products, that is from May 17, 1974 to January 1, 1978. And that RA 3823, as implemented by Mines Administrative Order No. V25, and PD number 463, which are the basis for the exemption granted to defendant, are special laws, whereas the municipal ordinance mentioned in the complaint, which are based on PD number 231 and P.D number 426, respectively, are general laws, and that it is axiomatic that a special law cannot be amended and or repealed by a general law unless there is an express intent to repeal or abrogate the provisions of the special law. The trial court rendered a decision ordering defendant to pay the amount of P161,875 as manufacturers and exporters' taxes and surcharges. Issue: 1. Ordinances NOS 5 and 10 of Lugait apply to Floro Corporation notwithstanding the limitation on the taxing power of local government as provided for in Sector 52 of PD 231 and Sector 52 of PD 463. Held yes. Ratio: Floro Cement Corporation holds that since ordinances NOS 5 and 10 were enacted pursuant to PD No. 231 and PD number 426, respectively, said ordinances do not apply to its business in view of the limitation on the taxing power of local government provided in Sector 5M of PD No. 231. Petitioner likewise contends that cement is a mineral product, relying on the case of Cebu Portland Cement Company v. SCIR. Petitioner further contends that the partial exemption was rendered absolute by Sector 52 of PD number 463, which expressly prohibits the province, city, municipality, barrio, and municipal district from levying and collecting taxes, fees, rentals, royalties or charges of any kind whatsoever on mines, mining claims, and mineral products. Any law to the contrary notwithstanding. On other hand, while respondent municipality admits that petitioner undertakes exploration, development, and exploitation of mineral products, the taxes sought to be collected were not imposed on these activities in view of the mentioned prohibition under Sector 52 of PD number 463. Said taxes were levied on the corporation's business of manufacturing and exporting cement. The business of manufacturing and exporting cement does not fall under exploration, development, nor exploitation of mineral resources as defined in Sector 2 of PD number 463, hence, it is outside the scope of application of seconds 52 of said decree. On the question of whether or not cement is a mineral product, this court has held that it is not a mineral product but rather a manufactured product. While cement is composed of 80% minerals, it is not merely an admixture or blending of raw materials, as lime, silica, shale, and others. It is the result of a definite process, the crushing of minerals, grinding, mixing, calcining, adding of retarder or raw gypsum, in short, before cement reaches its saleable form. The minerals had already undergone a chemical change through manufacturing process. It appears that the foregoing cases overruled the case of Cebu Portland Cement Company vs. CIR, which was cited by petitioner. On the exemption claimed by petitioner, this court has laid down the rule that as the power of taxation is a high prerogative of sovereignty, the relinquishment is never presumed, and any reduction or diminution thereof with respect to its mode or its rate, must be strictly construed. And the same must be couched in clear and unmistakable terms in order that it may be applied. More specifically stated, the general rule is that any claim for exemption from the tax statute should be strictly construed against the taxpayer. He who claims an exemption must be able to point out some provision of law creating the right. It cannot be allowed to exist upon a mere vague implication or inference. It must be shown indubitably to exist, for every presumption is against it, and a well-founded doubt is fatal to the claim. The petitioner failed to meet this requirement. As held by the lower court, the exemption mentioned in seconds 52 of PD number 463 refers only to machineries, equipment, tools for production, etc., as provided in Sector 53 of the same decree. The manufacture and the export of cement does not fall under the said provision, for it is not a mineral product. It is not cement that is mined, only the mineral products composing the finished product. Furthermore, by the parties' own stipulation of facts submitted before the court a quo, it is admitted that Floro Cement Corporation is engaged in the manufacturing and selling, including exporting of cement. As such, and since the taxes sought to be collected were levied on these activities pursuant to Sector 19 of PD number 231, Ordinances NOS 5 and 10, which were enacted pursuant to PD number 231 and PD No. 426, respectively, properly apply to petitioner.